Hello, my name is Jessica Pittman, and this is my presentation on the competence to waive the right to counsel and to represent oneself. Melton starts by talking about decisional competence, and that's defined as the competence to make a particular decision. Decisional competence can include some of the following: competence to consent to search and seizure, competence to exercise and the right to avoid self-incrimination, competence to enter a plea, competence to waive the right to an attorney and represent oneself, which is what we'll be focusing on today, and competence to refuse an insanity plea. When it comes to representing oneself, this decision deprives the defendant of a legally trained advocate and is rarely the defendant's best decision. This could also increase the likelihood of criminal punishment. According to Melton, the defendant must be made aware of the dangers and disadvantages of self-representation so that the record will establish that he knows what he is doing and his choice is made with eyes wide open. So in other words, the defendant not only must be competent to understand, but actually understand the consequences of the waiver of his decision. In Freda versus California, Anthony Pascal Freda was charged with grand theft. He filed a request to represent himself in the Superior Court of Los Angeles County. The judge initially accepted the request, but later called Freda back in to question him about his knowledge of the hearsay rule and other court proceedings. Based on Freda's answers, the judge determined that Freda did not intelligently and knowingly waive the right to counsel, and the judge appointed a public defender. The jury convicted Freda. On appeal, the California Court of Appeals affirmed the trial court judge's ruling that Freda had no constitutional right to represent himself, and the California Supreme Court denied the review. So the important findings from this case was the Supreme Court ruled that the Sixth Amendment guarantees the right for defendants to represent themselves. Justice Stewart declared that the procedural rights of due process belong to the accused and not the counsel. They failed to define the competence to waive counsel and emphasized the defendant is not incompetent to waive counsel due to the comprehending technical language, matters such as hearsay rules or the rules governing selection of a jury. To look at is Godinez versus Moran. In this case, Richard Allen Moran allegedly shot 3 people and attempted to kill himself. He pleaded not guilty to 3 counts of first-degree murder in a Nevada state court. After a court-ordered psychiatric examination, Moran was found competent to stand trial. 2.5 months later, Moran told the court he wanted to discharge his attorney and change his pleas to guilty. Moran said he wanted to prevent anyone from introducing any favorable evidence. After some questioning, the judges accepted Moran's waiver of his rights to counsel and the guilty pleas. The court sentenced him to death. The Supreme Court of Nevada affirmed as 2 of the murders. After sentencing, Moran claimed he was mentally incompetent to represent himself and sought post-conviction relief in state court. The court rejected Moran's claim based on findings from the psychiatric evaluations. The Supreme Court of Nevada dismissed his appeal. Moran then filed a petition for habeas corpus in federal district court. The district court denied the petition, but the U.S. Court of Appeals for the Ninth Circuit reversed, concluding that there was enough doubt at the time that Moran pleaded guilty that the trial court should have had a hearing to evaluate whether Moran could make a reasoned choice among the alternatives given. The record did not support a finding that Moran was capable of making a reasoned choice. The findings of this case was the court found that if a person was competent to stand trial, they were automatically competent to plead guilty and waive their right to an attorney. Also, defendants must be made aware of the dangers and disadvantages that come with self-representation. The next case that we'll look at is Maskell versus Wiggins. On January 17, 1972, Carl Edwin Wiggins robbed a Piggly Wiggly store in San Antonio. He was convicted of robbery and sentenced to life in prison, but his conviction was set aside due to a faulty indictment. At the first trial, Wiggins waived his right to counsel. On April 16, 1973, about 2 months before his second trial was set to begin, Wiggins filed a request for counsel and rescinded his earlier waiver. His feeling towards his standby counsel remained volatile throughout the trial. Wiggins was convicted in his second trial. He moved for a new trial and argued that his standby counsel interfered with his defense, but the court denied the motion. After he exhausted direct appellate and state habeas relief, Wiggins petitioned for federal habeas relief in district court. The district court denied his petition, but the United States Court of Appeals for the Fifth Circuit reversed. Some important findings from this case was that standby counsel may be appointed to assist the defendant without violating the right to represent themselves, as long as the assistance does not interfere with the defendant's control over the defense. And also, the jury must understand the defendant is representing themselves even though standby counsel is present. So even though they're seeing other people and attorneys sitting at the table with the defendant is still in charge of the case. Melton refers to standby counsel as a lawyer who assists a client who has invoked their right to self-representation. Some other well-known cases where the defendants represented themselves. The first one is Bundy versus Florida. Ted Bundy had represented himself on 2 murder charges in Florida. The second one is Gideon versus Wainwright. Clarence Earl Gideon was accused of felony breaking and entering in Florida, and he was forced to defend himself because it was not a capital crime. 5 years later, the court later overruled this decision. There's also a short video that ties into that. And the next one that we're all familiar with is the United States versus Roof, where Dylan Roof represented himself on 9 murder charges in South Carolina. Some reasons why defendants might choose to represent themselves include defendants' attitudes. A lawyer won't be of any help because I'm guilty. Paranoid ideation. All lawyers are against me. Fantastic objectives. A defense based on the assumption that a murder victim is not dead. Irrational beliefs. Supernatural powers will prevent the jury from returning a guilty verdict. Or the ability belief, which believes that they will do better than their lawyer. Lastly, the discussion question that I came up with was, how should courts balance a defendant's constitutional right to self-representation under the Sixth Amendment with the need to ensure that the defendant is competent enough to waive the right to counsel and effectively represent themselves?